Okay. Are we ready to go? 3, 2. Great. Welcome back, everybody. Part 2 of our scaling startups across markets. Now we're going to have a conversation about intellectual property. So is intellectual property the only property that goes up in value, or is it just a house of cards? So Dr. Jack Severs is here from JJE. Now, Dr. Jack is actually a physicist, a material scientist, as well as a patent attorney. So intellectually no slouch. So I think he's in a great position to tell you all about it. So please welcome Dr. Jack Severs to the stage.
There we go. Hi, everyone. It's the first time I'm more used to giving these presentations to my webcam over the last 18 months, but yeah, looks like we're sorted now. So yeah, thanks a lot, Maxine. As Maxine says, my name's Jack Severs. I'm a UK and European patent attorney, and I lead the HealthTech group at GJE. GJE are a specialist IP law firm based here in London and also in Munich. I'm also an IP advisor to a number of accelerators and incubators across London. And the focus of my work is really advising health tech companies of all sizes, but particularly early stage companies, how to use IP strategy to protect their innovation. And I think IP strategy is particularly relevant at the moment. We're going through a period of rapid innovation in health tech. But my experience is that there's still a lot of misconceptions out there about the best way to protect these technologies, particularly new digital health innovations, which really fall at the intersection of a number of kind of complex areas of laws, which I think is the reason why there's a bit of uncertainty about the best way to use IP strategy to protect these inventions. So my aim today really is to explain what we mean by IP strategy, and then actually go on to look at some of the questions that come up most often in my discussions with health tech companies. So actually look at 5 points, which I'm hoping will be relevant to some of the companies here today and watching virtually, to discuss, some of the most important considerations in IP strategy. So, as I just mentioned, we're really undergoing a period of rapid innovation in healthcare. The graph on the right, if you can see that, shows the numbers of patents filed last year at the European Patent Office, and what it shows is that there were more patent applications filed for health and medical technologies than any other field. As you might expect, biotech and pharma patents also increased rapidly, and we're also seeing really strong innovation in computer tech and digital communication, and it's particularly these technologies which are now being applied to solve problems in healthcare. But a point, just an observation I'd like to make about this, the graph on the right there shows the top applicants, so i.e. the companies filing the most patent applications. And what this shows is that actually the companies filing the most patent applications are predominantly in the digital communication and computer technology space. And actually, you've got to get pretty far down the list to about the 15th or 20th company before you get to a company that's filing patent applications in health tech. And what I think that shows is that, this innovation that we're seeing is really being borne by the small companies, so innovative SMEs, like some of the companies we're going to be hearing from later today. And I think that's really promising. But innovation is all well and good. But what those companies really want to do is harness that innovation to grow the business, to seek investment, and ultimately to promote the widespread adoption of those technologies. And what I'm going to argue is that IP strategy is what's needed to be able to do that. So this is one demonstration of why IP strategy is important. This is data from a report from economists at the European Patent Office, who surveyed, I think, about 170,000 SMEs across Europe. They looked at their IP portfolios, and they looked at how successful they were as companies in terms of how quickly they were growing. And what the graph on the left shows is that actually those companies with an IP portfolio were much more likely to be high growth companies. It's got to be taken with a slight pinch of salt, given that, there's a clear marketing angle here from the European Patent Office trying to encourage people to file more patent applications. But I think, nevertheless, it does show a clear link there. And what I find more interesting is actually this graph on the right, which shows that those companies that are using the IP system as a whole, i.e. filing combinations of design rights, trademarks, and patent applications together, are much more likely to be these successful high growth companies. So what is IP strategy? Well, I'm sure many of you will be familiar with the basic IP rights. So I won't go into too much detail on what each of those do. But a key point I want to get across today is that IP strategy goes beyond simply filing a patent application or registering a trademark. It's about asking how that would bring value to the company, and assessing that value really means that you need to look at the specifics of the technology, the business plan, and the environment in which the company's operating in, and then making a thought through strategy based on those factors. And so my job involves working with both health tech companies to help them develop and implement an IP strategy, and review that as the company grows. But also we're on the other side with investors, so supporting IP due diligence, looking at the IP portfolios of potential investment targets, looking at the strengths and weaknesses, and then providing advice, recommendations, and how they can strengthen the IP position of those companies and reduce the risk in their investment. And obviously that work feeds back into the advice that we can give to early stage companies in how they can strengthen their IP position to become investment ready. So to summarize, the key point I want to get across is that it's not simply about filing IP rights because you have the opportunity to do so. It's about asking what value those would bring. It's about use of the IP framework as a whole, an ongoing plan to develop and capture your IP, a plan to mitigate and manage the risk from third-party IP rights, so your freedom to operate position. And the kind of headline point is that this will depend on the specifics of your technology, your exit plan, competitors, and the global IP environment. Okay, so that's kind of a very brief summary of what we mean by IP strategy and trying to kind of demonstrate its importance. What I want to do now is try to bring out some of the points that I discuss most frequently in these conversations with health tech companies. It's a difficult thing to do. If you were here for the last panel, you would have heard that, health tech is a very big space. There's lots of different technologies within that umbrella. But these are some of the points that I find myself discussing most often. And I'm hoping that a lot of them will be relevant to people watching here today. So in order to demonstrate some of these points, I think it's useful to look at an example to illustrate some of these. So this is a fictional company, PlaqueSnap. They're developing a technology which involves assessment of your oral health. So a user can take a picture with a smartphone of their mouth. That image is then sent to a trained machine learning model. It's processed to provide an output in terms of a health condition prediction, to provide an indication of your gum health and your plaque levels. So you'll probably be able to identify possible different IP rights that might be relevant here. So I'll use this as an example to kind of demonstrate and discuss some of the topics that come up most often. I would say without a doubt the topic that I discuss most frequently with health tech companies is whether and how they can protect their software innovation, particularly whether they can file a patent for their software. There's a lot of misconceptions, I think, out there around this. So I'm trying to give some kind of practical guidance to demonstrate this, although I think I could probably give this full talk just on this one question, but I'll try to summarize the key points. So just like any other invention, a software invention needs to firstly be new, i.e. have at least one new feature over anything that's been done before, the closest thing that's already out there in the public domain. It needs to be inventive. So those new features need to solve some kind of problem in arguably a non-obvious way. So they're the kind of two common requirements to any invention. The source of most of the confusion is this third requirement that the invention needs to be what's called technical. And the kind of difficulty here is that there's no one black and white definition for what technical is. It's intended to be to evolve with the case law. When the patent statutes were being written, people weren't using machine learning routinely, to solve problems. So it's had to adapt to new technologies as the Patent Office decides through case law what is considered technical and what isn't. But these are some of the most relevant issues, I think, to health tech. So the key point is that a technology is technical if it doesn't fall within one of these fields, which the Patent Office excludes from patentability. So from ones that are particularly relevant to health tech are on the right. There's a large number of software platforms out there, digital health platforms, which connect patients with clinicians, which provide information on particular conditions. And these, there's a number of very successful companies which are producing these, and they're really important to solve some of the problems with, providing remote care more efficiently and so on. From a patent perspective, if you are using routine software to provide new information or connect patients and clinicians in this way, that's very unlikely to be considered patentable unless there's some particularly innovative aspect to that software. Another common one that comes up is where you're kind of using routine software to automate administrative procedures. So one example that I've seen a couple of times is a platform which takes input as a patient questionnaire and then calculates a treatment plan based on that. So again, it's kind of using conventional software, but just using it to automate an administrative process. The final one is that the Patent Office says you can't have protection for a mathematical method. This is very relevant because obviously AI models, machine learning methods are mathematical methods. So what are the issues here? Well, actually, you can get around this if you are applying a mathematical method, so a machine learning model, to solve a particular problem in health tech. And the key point I want to get across with this is that the Patent Office does look very favorably on healthcare and medical problems and using software to solve issues within this field. So if you're using software to control some hardware or receive input from some hardware, if you're using software to process data to provide some kind of output on a health condition, for example, using a machine learning model to process patient data to provide a health condition prediction, then that is very likely to be considered technical and patentable. So a brief comparison here, we've got PlaqueSnap on the left. They are applying software to process some patient data to provide a health condition prediction, to provide this indication of gum health. And so that is certainly a technical application. The image on the right is intended to illustrate a physiotherapy platform which connects users with physiotherapists, which provides information on physiotherapy. This might be the first software platform ever to do that. Might be the first physiotherapy platform out there where you can do this kind of virtual physiotherapy. But if it's just using conventional software and all the new features relate to the type of information which is being provided, that is very unlikely to be considered technical, and you'll need to look to other means to protect that kind of innovation. So yeah, that won't be considered technical by the Patent Office. I think a particularly relevant question which isn't asked so much by companies that I speak to, but I think is arguably more important, is actually this question of, is patent protection the right option? Because I think often there's kind of pressure, or investors ask, have you filed a patent application? That leads companies to go to speak to a patent attorney and say, oh, okay, well, can I file a patent application? And their eyes probably light up and they say, yeah, sure, I'll file a patent application for you, without anyone actually ever asking, what is the value of actually filing this patent application? And so in this situation, say the new innovative aspects are the algorithm. So, they've developed a new machine learning model which processes these images a lot more efficiently. Yes, in theory, they can get patent protection for that. But would that actually bring any value to the company? Would PlaqueSnap ever be able to tell whether a competitor was using those same algorithm features to be able to enforce their patent? If it's all back-end features, that's very unlikely. On the other side, at the heart of the patent process is this agreement whereby you can have a 20-year monopoly for your technology, but you need to disclose exactly how it works. And so their algorithm, which they might otherwise have kept confidential, they now have to publish, and it will be released to the public. So you really have to look at the specifics of the business model and ask what value is that patent application going to bring. And there's lots of different factors here. If they could protect that broadly so that it would map onto the kind of front end of a competitor device, then that could be really strong protection. If you're protecting aspects in how that image is prepared and sent to the algorithm, that could be really strong protection. But you need to look at how broadly it can be defined. There's other aspects. Is a patent important to licensing negotiations? Are you going to publish anyway on your results? So there's just a lot of factors that need to be taken into account. But make sure you always ask your advisor, is patent protection definitely the right option? This third issue is one which I think is becoming increasingly important. It is the fact that most patent systems around the world do not allow protection for medical methods, so methods of treatment performed on a human. And that's supposed to stop clinicians being restricted by any patents out there from treating a patient. The conventional wisdom here is that, that doesn't matter. It's really easy to get around. You can just file for a product. So rather than claiming the method, you claim some apparatus which is used in the method. I don't think that advice is quite as relevant as it used to be, particularly because there's a lot of new technologies such as digital therapeutics, which this is really relevant to if you're using software to provide therapy. Another area which we're focused on quite significantly is the use of software to control some kind of process in surgery or therapy, because if you're in that case, it really is a software method which is providing the therapy. And in combination with this, there's some kind of new case law in which these exclusions are kind of been interpreted more broadly. So my point here is really just to make sure that you ask your patent attorney if you're working in these areas. I think sounds like I'm running out of time, so I'd like to kind of go through the last two quite quickly. The first one is, I'm often asked, when's the right time to file a patent application? Or the question I often get asked is, do I have to get this working perfectly before I file a patent application? The answer is no. You can file a patent application to an idea before you've done any kind of research at all. But what I would say is that if you haven't done sufficient development to really understand the key features, then the patent application is not going to be particularly valuable. So you need to weigh up where you are in the development process. Do you have a requirement to disclose? And also, of course, funding is relevant as well. But I can chat to anyone who's got questions on that in more detail afterwards. The last one is ownership, just because this is the area where we see the most kind of issues, and particularly in due diligence, where looking more closely at a company's portfolio, you find out that actually they don't own the IP they think they do. And it's particularly relevant for health tech companies because there's a lot of collaboration, there's often different parties involved. So the key point is just make sure from an early stage you've got agreements in place to understand who owns the IP, how the IP passes to you, so that you can file a patent application. Okay, pretty much final slide. I've kind of rattled through a few of the key issues there that come up the most often, but as you'll kind of gather, it really does depend on the specifics of the company and the technology. You should tailor your IP strategy to those things. You should really ask the question, what value is this approach bringing to the company? And I would always suggest starting early is really important, because you can really just with a small amount of consideration at an early stage avoid some of the mistakes and build significant value for later on in the process. And this last slide is just a bit of a plug really for GJE, but on that starting early point, that's the reason we provide these kind of free consultations for companies at an early stage. They have the opportunity to talk through some of their considerations, some of their questions on IP. And so if you are interested in one of those, please do get in touch. I'm not sure this 2D barcode will work quite as well as when I'm doing these presentations just online. But yeah, come and get in touch. Come over to our booth, which is just out here on the right. And yeah, happy to answer any questions. Thanks a lot.
Okay, thank you very much, Jack. So we're going to take a break now until 11:30, but please, if you want to see the amazing 6 startups in the Edison Accelerator of Wira, do make sure you get your seat here before 11:30. So